So, what are the basics of filing for divorce in Connecticut? Well, a lot of people think that the way it probably works is you hire a lawyer, your lawyer drafts paperwork, and they file it with the court, and then they serve it on your spouse. So, file it with the court, and then your spouse finds out. One of the things that surprises a lot of people is that that's actually not the order in Connecticut. You serve the divorce paperwork on your spouse, and then once you receive back that service, you then file it with the court. So it's a sort of reverse of the way most people assume it will happen. First, you're formally legally telling your spouse, and then you're formally legally telling the court. So that's the basics of filing for divorce. It's first a summons and a complaint for divorce and a notice of these automatic court orders that go into effect when you initiate a divorce. That gets served upon your spouse, usually by a state marshal, or if your spouse already has an attorney, a lot of times attorneys will agree to accept service on behalf of their clients. So you don't have to serve your spouse at home or at work or anything like that. You just serve their attorney's office. So that's the very, very basics of how you file for a divorce. So when you file for a divorce, part of it is that you're filing papers, right? Well, what are those papers? What is on those papers? All right, the first thing is a summons. A summons summons your spouse to court. It's the way you initiate a lawsuit, and a divorce is a lawsuit. The other thing that we file when you start a divorce is what's called a complaint. A complaint is how we ask for what we want. So we're filing for divorce. We're citing the grounds for divorce that we're filing under, and we're asking what we want in the divorce. And don't worry, that doesn't mean I want 1/3 of the house and 100% of the retirement. It's not that specific. What the more general thing that you would tend to see in a divorce complaint is something like, I am requesting spousal support or alimony. I am requesting a fair and equitable division of property. I am asking for joint custody. So these are broad things. It's essentially you're telling the court what you want it to rule on or order. You're not telling them what the specifics are of what you're asking for. So I think that can be a little confusing. Some of the other things that tend to accompany a divorce in Connecticut, you will share with the court the names of your children and their ages right up front. You'll also ask for anything urgent that you need right then. You might file motions that indicate that you want something like the right to use the home by yourself without your spouse entering. Or you might ask for some orders around child support or custody, depending on how people are living. But that's really a addition. The core things are the summons, the complaint, information about the children, and then the automatic orders. And what the automatic orders are in Connecticut is any divorce or family law action has certain standing court orders that go along with it. One of them, for example, is it says when someone files for divorce, neither spouse can drop the other from their health insurance. No one can engage in any unreasonable spending that's out of the normal course. These orders are designed to keep the status quo in place while we figure out the initial stages of a divorce. And those automatic orders are you're subject to them when you serve the papers on your spouse, and your spouse is subject to them when they receive them. So both spouses have to follow these automatic orders. And that's why they're included in the packet that goes from the person that initiates the divorce, who in many cases is called the plaintiff, To the defendant, the person who's receiving service of the divorce, both people are playing by the same rules while the divorce is pending. Before you file for divorce, here's my best advice about what you should do. You should get clear on what you want for the future. If you get clear on what you want for the future, you will have a better compass rose as you're going through your divorce. It will help you prioritize what matters most to you. So, for example, say you're someone who wants to make sure you have stability during retirement. Well, in the heat of the moment, when someone is, trying to engage in discussions about the grandfather clock, it's good to remember that you really care about retirement to keep your focus on the things that matter to you the most. The other goals I would think about as you're preparing for your divorce are, what are your goals for the process itself? What's your hope in terms of how long the divorce will take? What's your hopes in terms of whether or not you'll be able to reach agreements outside of court or in court? Where is your willingness to invest in attorney's fees to get there? How much emphasis do you want to put on outcomes over things like how long it takes and how much it costs? Weighing those things in advance and starting to think about what you really want to emphasize for the divorce itself, in addition to after the divorce, can really set you up to start your divorce with a clean head and focus the strategy for the divorce on those things that matter the most to you. The other thing I would do as a practical matter is I would meet with a lawyer and really talk about the different divorce processes. So before you start the divorce, whether that's filing a complaint with the court or hiring a mediator, get your own lawyer to give you advice on what the best process is for you based upon your goals, time, legal fee investment, outcomes, hopes for the future. Which divorce process is most likely to support those goals? So I would get that information before I kick off the divorce. The other thing I would do is just get my arms around the financials. There's a lot of financial exchange of documents, especially in the beginning of a divorce, and it can be a real boon and also give you a sense of calm control if you put your arms around bank statements and old tax returns and have them in a file, so that when your lawyer is asking for them, it's easier to just share that information efficiently and effectively, and you can go on with the important work of making sure you're taking care of yourself during the divorce itself. One of the pitfalls I see when people are really new in the divorce process is having a misunderstanding of how we kick it off with service. Service is where your spouse formally receives the documents that initiate the divorce, the pleadings and the accompanying documents. And I think the misunderstanding of how this works can really be confusing and stressful. So let's avoid that and just talk about how it works. The first thing that happens is you don't file with the court and then serve your spouse. You serve your spouse and then you file what you served your spouse with the court. That's the order. There are two common ways to serve a divorce. And right now we're in the divorce litigation world. We're not in collaborative divorce. We're not in mediation. I'm talking about litigation here, the classic traditional way to get divorced, the way the vast majority of people divorce. You meet with your lawyer. You work with your lawyer on what divorce process makes the most sense given your situation, your spouse's situation, and your goals. In this case, let's say you come out deciding that the traditional way is probably going to be best for you. Then your lawyer will draft the documents that start the divorce. You'll review them, make sure they're good. They'll get signed and sent to a state marshal. Now, this is the most common way of accomplishing service. They're sent to a state marshal, and that marshal serves them. I want to note two things. When I said the word sent, I meant sent in the U.S. mail. Here is potential frustration number one. There is a gap between when your lawyer signs those documents and when the marshal receives them. So understand that. This is a little bit nuanced because there is some uncertainty about the timing of the service itself. So I like to make sure people know that the documents are going from the law office to the marshals in the US mail, unless the marshal happens to be nearby and picks them up at the law office. Then it is the marshal's job to serve those documents on one of two people, either your spouse themselves, or if your spouse's attorney, we know who their attorney is and they've pre-agreed to accept service, it's also possible for the marshal to serve your spouse's attorney, right? But let's assume that we're not serving your spouse's attorney. Let's assume that we're serving your spouse themselves. So we know that the law firm has sent the documents to the marshal, and now the marshal is going to try to serve your spouse. Well, that can happen a few ways. They can call or text your spouse based upon information that you've provided us and we've provided them, and arrange for a time for that to happen. This is most common. Usually it's they reach an agreeable location and time, and there's just a casual handoff that everyone knows is going to happen. That's one way. The other way is that they will locate your spouse at home or at work or somewhere else and serve the papers on them. But it's not dramatic like TV, or at least it shouldn't be, and rarely is. The final thing that can happen is something called abode service. The marshal may leave the divorce paperwork at the abode, the residence of your spouse. Now, if you live together, this is something to be aware of because you may have children at the house, you may have neighbors or friends that may not be ideal. So when we're talking about service, I like people to know that you don't have complete control over the timing of when your spouse will find out. So this is something to talk to about your lawyer if you have any safety concerns. If you just want to make sure that your spouse knows this is coming and you want to talk about how to have a conversation with them. If you want to think about if there's a way to get your spouse's attorney to accept service so that your spouse isn't being served directly. All of these things are things that we can work through. So, although certain things aren't within your control, the marshal's timeline, the marshal's availability, and things like that, it's important to know that there are things we can do so that you know what's coming and so that you can set things up so that your spouse isn't caught unawares if that would be a problem. Another pitfall we see when people start a divorce is they get the order a little bit wrong. And it's perfectly reasonable to think that the way they're doing things is the right way, but based on my experience, there's a little bit of a better way that is sometimes counterintuitive to people. So here's how it goes. You should meet with a lawyer before you pick your method for getting divorced. Let me tell you what I mean about that. In a lot of cases, people will decide to, for example, mediate their divorce before they've met with a lawyer to get advice on whether or not mediation is the best process. That's the wrong order. Hiring a lawyer and meeting with them for advice on what the best process is for you, given your goals and the situation you're in and what your spouse is like, that is a really good idea. It does not mean that a lawyer is going to push you to litigate the divorce. At Reed Marcroft, we practice all three. We mediate, we do collaborative divorce, and we litigate. And the dog I have in the fight is getting you in the process that is most likely to achieve your goals. So say, for example, you are attracted to mediation and you want to learn more about it because you think it will speed up the timeline of your divorce. But upon talking about it in a room with an attorney who's trying to help you select the best process, you learn that in a mediation, it really requires both people to be motivated to keep appointments, to do their homework in between sessions, to fully engage in sessions. And you just think, there's no way my spouse is going to do that. Well, in your case, it may turn out that mediation is a slower method than one of the other methods. The point is, don't pick your process before you meet with a lawyer. Meet with a lawyer, get the information and insights you need about your goals so that you can pick the process that's most likely to help you achieve those goals. One of the main fears that people have when they go into a divorce is, how long am I going to be doing this divorce, right? It ties to the even more common fear, which is the fear of the unknown, the anxiety that comes from not understanding what's next. One of the things that we strive to do here at Freed Marcroft is make sure we're keeping you knowing what's next and how long it tends to take so that you can wrap your brain around the time frame. So most divorces probably take, and this changes over time and it changes based on whether you're mediating or it's a collaborative divorce or a litigation, but generally speaking, most divorces take kind of around between 8 months and a year and a half, but closer to the year mark. That's the general range. So I would say that the vast majority kind of fall in that year sort of time range, but it's important to know more about that. The first thing it's important to know is during your divorce, there are periods of a lot of activity and then periods that feel like nothing's happening at all. So as part of the timeline, it's not just like what's the total timeline or what are the timelines of the different phases within a divorce, but it's also like, how engaged do I need to be in my divorce throughout it? And that is a really interesting question. So if you're litigating your divorce, there's a lot of work and hustle up front that you're really integral to. Gathering the basic information, helping us understand your goals, getting us the information we need about financials. There's a lot of work up front, perfecting your first financial affidavit and signing it. And then there's generally a court appearance pretty early on, called a resolution plan date. And so it can really feel at the beginning of your divorce like you're making a lot of progress. You are. And like things are moving really quickly. They are. But then another thing happens where discovery really starts in earnest. And both sides have a minimum of 60 days to exchange the sort of basic documents. And that period can kind of feel like a little bit of a hurry up and wait. So after we're through the initial things, all the way through the resolution plan date, it can feel like there's a lag, like nothing's happening. But the thing about the exchange of information is it's what sets up resolution. So we need to have our arms around the information to know if there's anything we need to know more about. And we need to have our arms around the information in order to start to think about what a possible settlement might look like. So even in the times, the down times, things are happening. You're setting yourself on a path to resolve your divorce. I think it's just important to have your expectations set so that you know going in, it might feel like a lot of work and not a lot of work, a bump and then a lag. And it's also good to know, I think, that your whole divorce won't be like the beginning. It won't require as much of your time while it's grinding on with your lawyers doing work and exchanging documents. So sometimes you're super involved, but also there will be breaks where you're less involved. Don't worry, that is part of the process. It is good. We are moving forward. And if you think about your divorce as a wave, that probably will be longer than you want it to be, but not as long as a different kind of civil lawsuit, which can take 2, 3, 4, 5 years. Compared to that, divorces tend to resolve rather quickly. And of course, if you're in an out of court process, there's even more flexibility around the timeline because we are not working with court deadlines. We're working with your deadlines. So as long as you and your spouse both live up to them, then things can progress with more expediency, if that's your desire, your shared desire, or with less rush if that's the priority because of other things happening in your lives. If you'd like to know more about what you should think about before you file for divorce or filing for divorce in Connecticut, please reach out.